back. Our next workshop is The Business of Art, Contracts, Creative Work, and Employment. At Vanguard Culture, we are committed to giving creatives the tools and resources they need to thrive. And today's session is all about helping you build a strong and sustainable career. I come from a long line of creative professionals, musicians, poets, actors, models, TV personalities, and architects. And I'm grateful to them for modeling how to take one's passion and talent to the next level by having a business mind about their practice. So today I am thrilled to be joined by two incredible experts from Better APC, Sam Mazzeo and Olivia Casellini. Together, they bring deep expertise in law, intellectual property, and creative business practices. In this session, they'll guide us how to navigate contracts, understand your rights, and protect your creative work. Let me just bring you in here. Welcome. Thank you so much for being here. We've been working with Better APC for years to provide workshops that support the arts community and to ensure that creatives have the skills and resources to make a living doing what they love. And I'm sure this is going to be a very insightful and empowering conversation. So Sam and Olivia, before you get started with your presentation, I just wanted to have the audience get to know you a little bit. I'd love it if you could just share a moment in when you realize the importance and the impact of the work that you do.
Olivia, you want to kick it off?
Sure. To be honest, I don't think there's a single moment that I discovered that. I feel like I'm constantly rediscovering how important it is. The internet is an incredible tool, but unfortunately, it's also a tool that has created this sort of age of misinformation. And so just, every day I'm running into people who are extremely well-meaning and kind and great at what they do, but they're not lawyers. I just run into that all the time and think, gosh, well, I'm glad there are artists and I'm glad there are lawyers because we need both.
Yeah.
Yeah, and I'll pull on that thread as well because I feel like I find myself saying often these days that I don't know what I would do without art and music and all of the things that bring us that joy. And I think that that also kind of goes with your question because I find that a lot of the time when we advise people, the stuff that we know so well in our expertise can be so illuminating and so sort of like tremendously helpful to people that don't know the things that we know. And so for us, it's always really a gratifying experience when we're able to share stuff that we just know from our work, and it is really instrumental for someone in helping them shape the direction that they're going to go with their work and their creativity or whatever it is that they're doing for their business. So it's definitely, it can be a frustrating profession for sure, mainly dealing with other lawyers, but it's a gratifying one too.
Thank you so much. That's funny. But I love,
It's
if
true.
you don't know Better APC, they are so accessible. They are so charismatic. They send you memes. I mean, it's just awesome because it demystifies and it humanizes the work that they do. And I'm so grateful for you all. I'm going to step away and I'll let you get started with your presentation and then I'll just pop in at the very end. But thank you so much again. Here we go.
Thank you.
Thanks for having us.
All right. So we hope that you guys are all enjoying this awesome day of information and learning and education, and we hope to add to that. So as you can see here, you've probably got questions about the legal, and we hopefully have answers. Quickly, I'm going to run through our bios here. I'm not going to hit all the points, but Olivia handles our labor and employment for our clients. She also helps with contracts, copyright. She makes a mean guacamole. She's definitely a SPF evangelist, and her dog is one of the most adorable dogs I've ever met. Myself, I do a lot of different things. For the business, I do trademark, formation of businesses and nonprofit organizations, sometimes handle investment rounds for businesses, and then also work with contracts and copyright and trademark. And so a lot of things that sort of overlap with the creative industry. And I am not a big fan of birds. I'm coming around on that though. All right, so for our legal topic today, this is the business of art, contracts, creative work, and employment. And we're going to cover these things at a relatively high level, and that sort of feeds into this disclaimer. As lawyers, we have to do this. I'm not going to read the whole thing, but the gist is what we're explaining today, and while you're watching us explain this, it is not specific to your circumstances. So what we're advising is not something that you should go and act on without speaking to an attorney to make sure that your specific facts and circumstances are being taken into account. as you're going to learn through our presentation today, a lot of the law is very specific to those facts and circumstances. So this is general, it is not legal advice, so please don't act on the stuff that we are talking about today. So we are going to start with some contract considerations. What we find a lot in our work is that a lot of people think that contracts are sort of a really black and white thing, which I guess, on paper, it literally is black and white, but they're not this one size fits all type of situation. In fact, different industries, different types of deliverables, different types of intellectual property, creative work, trademarks, copyright, these things all have different rules. They have different practical considerations, even things about timelines and payment, and also the rights to that creative work. So these things are very important, and the contracts themselves can actually alter your legal status as far as employment goes, or even potentially legal status as a resident. So it's really, really important to know what you're entering into for these reasons. And even more importantly, as a creative, really important to make sure that your contracts are protecting your work. If that is what that contract is about, that's your livelihood, and you want to make sure you're protecting it. So that's sort of some of the legal considerations. You'll see the note here, though, that in addition to that, part of the difficulty in contracting is that there's a fundamental understanding gap between you as an artist and you making creative work, and then who you're contracting with. Presumably they're contracting with you because they can't make the work you make. And so they have a fundamental misunderstanding of how those rights work and what it is you're doing. Those things all definitely factor in, and that's why it's so important to understand these nuances, which Olivia is going to explain further.
Great intro, Sam. Couldn't agree more with the fact that there is an understanding gap a lot of the time. But the good news is a lot of this information you can really kind of hone in on gut sense of when you can do things yourself and when you need to bring in a lawyer. I personally think IP ownership is an area where you should bring in a lawyer because it's extremely tedious, and there are a lot of moving parts that a lot of people don't understand. So, these are just two high-level bullet points that we see all the time. A lot of the time people think if I contract somebody to create intellectual property, that's the IP. If I contract somebody, if I hire them to create intellectual property for me, obviously I own the IP. And that makes conceptual sense on a very human level, but it's not the legal understanding of how IP works, and we're going to get into what actually is the rule around that in just a minute. Another misunderstanding is a lot of people think because you're our employee, we're going to own anything that you create while you work for us, whether that's stuff you do off the clock, whether that's stuff that you do for a second employer that hired you after you started working with us. These are incorrect assumptions, but a lot of the time the artists and creatives that we speak about, because they don't know they're incorrect, they just sort of accidentally go along with them. And so what I hope for you to kind of take away from the sections I'm going to be talking about today is that sort of gut sense of what I was saying earlier, of just knowing when something's sort of off and knowing, do I need to explore this further? Do I need to go talk to an attorney before you sign anything? Okay, so we just talked about those two incorrect assumptions. Let's talk about what the correct rules are. There are these things within the law that are called default laws, and those are just, as the name would suggest, the default legal principles that will apply to a situation unless you change them, usually through contract. Sometimes they can be changed, sometimes they can't, so that's a little bit tricky, but that's what we mean when you see on the slide default laws. So the default law is that if the party creating the intellectual property is an employee, then the hiring entity, that's the employer, is going to own the IP by default. But as we talked about in that last slide, there are limits to that. It's not just you own everything as the employer that the employee creates. We'll get into that in a little bit more detail in just a second. If you're a contractor, on the other hand, an independent contractor, the rules are different. The rule here is the independent contractor is going to own all of the IP they create by default, even if they're being hired to create that, unless the contract specifies otherwise. So a written agreement in these two situations can potentially alter the default laws. Again, there are some parts that can't be altered, but generally speaking, both of these can be altered a little bit. So Understanding what you're signing, again, is always important, whether that be in employee or independent contractor land or completely different type of contracting. I'd never recommend just signing a contract because you want a job or you like the person that's handed you the contract or they're a friend or something like that. We see that a lot. And I don't have a percentage of how often it goes south, but it does go south a lot of the time. So I just recommend reading through everything really clearly, understanding what it actually means. And I do want to just stop here and say, because I mentioned the age of misinformation earlier, I think AI is really helpful for a lot of things. I don't recommend AI as your sole legal vetting device. It's great if you sort of just want to get maybe like a little bit of background, but I work with people who 50-50, half of the time, their understanding through AI is either pretty correct or completely wrong. So always double check it with an expert. Don't rely on AI for this sort of thing. Use it for like ideation, but not for determining if you should sign a 50-page contract. So yeah, and then the last little bullet to point out here is contractor laws are really, really tricky in California. They're becoming tricky all across the US. Just because the laws have been changing in the last few years. So if you are hiring a contractor or you are trying to be a contractor, that is an area where you should speak to a lawyer, if only, just to get your bearings. Maybe you don't have the budget to talk to them every time you want to hire a contractor or anytime you're going to be hired, but you should talk to an attorney at least once to just sort of understand the landscape. Okay. So we talked about those default laws, and I just want to pause here to kind of explain the background of why they work this way, because I think that can help you sort of conceptualize this a little bit more. So this is pretty wordy. I'm going to try to get through it kind of quickly. There are two main kind of underpinning ideas between these default laws. The first one for employers owning anything that their employee creates. It's because there's this sort of idea that if an employer is paying for the materials or the time of the employee, they should own whatever the employee creates as a result of that. Otherwise, it would be what we would describe as a windfall to the creator, the employee, if they could use their employer's, paper, pens, computer, internet, all of that for free, and also be creating this stuff on the clock, and then they could go sell it to whoever they wanted and the employer has no rights to it. That wouldn't be fair. So that's sort of the concept behind that default rule. Again, it's a default, so if any of that is kind of not true, then that could be different or it could be contracted differently, but that's the default there. And then the second one is about independent contractors. And that's sort of interesting because there's two things within that concept that matter here. Number one is the reverse of that first concept, number one, is usually true, where a contractor is usually not paid by the person that's hiring them for their materials and their expenses. That's usually something the contractor just sort of has to bundle into their cost of doing business. And a lot of the time, a contractor might be paid flat fee and not for their time necessarily. So again, it's sort of that reverse concept of why would the hiring entity own anything you create during your contracting period just because you are in a single contract with them. And then the second thing is there's a little bit of an idea that there's bargaining power between a contractor and whoever's contracting them that's different than employers and employees. In independent contractor relationships, it's seen as two businesses working together that should be about equal. So there's an idea that within that bargaining, everybody has the same power to sort of say, I want this, well, I'll give you this, you can have this, that sort of thing. And so whatever isn't bargained for, whatever isn't accounted for in the contract should be left to the contractor to use elsewhere, to sell it to the highest bidder somewhere else. So those default rules, as we were talking about, can be changed. So it's really important if you're an employee to look out for a few things in your employment paperwork to make sure that you understand what the rules are. Because the default sounds acceptable to a lot of people, but I have seen employee contracts where the language is just kind of all over the place and kind of messy and confusing and sometimes even outright illegal. So it is still important to read the rules, even if you're like, okay, I'm fine with the default. So the first thing, and this is true for many, many aspects of employment, not just at IP, but make sure that you have either an employment contract or an employee offer letter and job description that outlines the specific nature of your position. And then ideally your employer also has an employee handbook, which tends to be a little bit more broad and applicable to everybody within the organization. It won't necessarily be tailored to you, but both of those will usually define how employee work product works. And if it doesn't, that's a red flag. You want to make sure that you have that somewhere in writing so that later you don't get into some sort of, dispute over what the policy is. It's, you as an employee, you're probably likely to win that dispute, but it's just a headache. You don't want to have to get into it. So just make sure that's clear up front. And then the second thing, which is a little bit more nuanced and a little bit more legalese heavy, an area where you may want to just pay for an attorney's an hour of their time to just double check this. Make sure that your employee work product policy, which like I said, should be in that handbook, either describes the protections under this California Labor Code section, it's section 2870, or if it doesn't describe what that section says, it just explicitly names it. That section, I just took a tiny snippet of it below, basically creates a carve out that says anything you, the employee, creates off the clock, using your own materials, using somebody else's materials, is not going to be owned by the employer. And that's something that can't really be contracted around very easily. But again, it's just good to have it up front so everybody's on the same page from the beginning. It's way easier than handling it after the fact when people are fighting. Before I jump into contractors, one thing I want to note is for employers, it's sort of similar feedback here. You want to make sure you have this paperwork and you want to make sure that labor code section, you understand what it means, because it's just two sides of the same coin. Okay, for contractors, this one's a little bit more labor intensive perhaps, but if you're an independent contractor, you are technically a business owner and this is just part of doing business. What you need to do to make sure you don't end up in some sort of tricky IP situation is sit down and look at the work that you do and figure out what are you going to reuse over time for multiple clients and what is going to be more bespoke or customized for your clients. Because that's really going to determine what kind of legalese you need within a contract for the IP that you're creating. And we'll get into that specific distinction of what you need to reuse versus what is going to be bespoke a little bit more in just a second. But once you've figured out those two sorts of, I'm going to call them buckets of types of IP, consider creating a term sheet that describes what kind of IP protections you need for those two buckets in case your clients require you to use their contracts instead of your own. So I'm going to give you a really high level example. Facebook or Meta, Instagram, Spotify, those are all companies that I have personally helped our clients negotiate contracts with. Sometimes people are creating murals or art or installations for pop-ups and things like that. And those big companies will not let you use your own contract ever. It's easier for their legal department to use their own. So a lot of the time it can be helpful up front before you expend a lot of time and energy in that negotiation process to just say, here's my term sheet, this is what it needs to say. If it doesn't already say that in there, I need to understand if I have the ability to revise the contract at all. So it can just be a really easy way to get that all out up front instead of, like I said, expending a lot of time and money to try to negotiate a contract that might not even be negotiable in the first place. So that's my first suggestion here. The second thing is for creating your own contracts, because there are some scenarios where you might be working with smaller companies that don't have their own contracts, and then you definitely want to use your own. For those, I really just recommend against trying to create your own IP ownership language. We say license or assignment here in the bullet, but we haven't gotten to that yet in the slides. Really, it's just such a tricky area that trying to create that own language yourself, 9 times out of 10 when I see it, it's either incorrect or incomplete. So this is worth the money to pay an attorney to help you with. It's usually some sort of one-time fee to get this all drafted up for you. And as you can see in the example, I just used some of our fees, to kind of illustrate this for you. Our flat fee to help you create a contract is $900 flat fee. And then hourly fee to help you create a term sheet is $300 to $400 depending on the type of work you do. And it usually takes about an hour or less. Whereas the potential for lost IP or haggling and arguing over IP after the fact can be thousands of dollars over time. So it's really worth it to just get it done correctly the first time. Okay, ownership versus license. So I briefly touched on this a minute ago. When we're talking about, actually, I think that should probably say assignment versus license. When we're talking about IP ownership and how to decide who has what, there are really these two types of IP delivery that we're talking about, a license or an assignment. A license is going to be permission that you're granting for specified use of the IP, but you retain ownership ultimately. And assignment is where you transfer the full rights to the person that's paying for the assignment. And so the example Sam always uses that I really like is a license is sort of like leasing a car. So when you lease a car, whoever you lease from, they usually have rules around how you can use the car, how many miles you can use it within the term of the lease. Sometimes it'll have language about, if you beat the car up and you bring it back in at the end of the lease term, what that means for paying more or potentially having to buy out the lease. There's just a lot more that you have control over as the person leasing the vehicle and the person leasing the vehicle to the person who will be driving the vehicle. And the person who's driving the vehicle has very specific limits of how they can use that vehicle. Whereas an assignment is like selling a car. Once you've sold that car and the paperwork is done, you cannot control where that car goes, what kind of gas they use in it, nothing like that. So understanding these two differences is really important because, again, when we're talking about those buckets, if you're going to be creating something that you want to reuse over time with other people, a license is usually the way to go. Because if you use an assignment, you've said this client owns everything that I'm giving them. And that usually means you can't reuse what you're giving them. Some exceptions for that, but generally speaking, if you want to reuse IP, license is usually the way to go. Customize things where the client is paying for you to create something bespoke, something they don't want anybody else to have access to, assignment might make more sense there. So this is a very high level illustration of why we say just talk to an attorney before you try to do your own IP, because these tiny little details in just a single word can sometimes affect the ownership. So it does matter getting it right the first time. And then this is the last slide for me before I hand it over to Sam. Work for hire is a phrase that you will see in contracts, or at least I have seen in contracts constantly. Maybe you won't see them as often. But work for hire is a very specific type of contract clause for intellectual property that actually comes from federal copyright law. And so a lot of time people will put it in to basically say, whatever you're creating for me, I want to have the copyright to, and I'm going to use this federal law to bolster that claim. However, as I said, that's a federal law. And in California, our state law has determined that work made for hire or work for hire clauses actually can be really detrimental to the hiring party because it can turn the independent contractor into what we call a statutory employee. I'm not going to get into why that's a whole thing like I did with some of the other stuff, the underpinnings legally, but it's just a big deal because if somebody is accidentally an employee, you probably haven't been paying for their workers' comp or unemployment or disability insurance, and then you can get in trouble later on down the line for not having done that. So you just want to avoid accidentally making this person an employee, and you can do everything in a work for hire clause. You can accomplish that using an assignment clause instead. So just talk to an attorney before you try to use a work for hire clause or you sign one. Usually what you're trying to accomplish can be done. There's just a specific way to do it that you might not be aware of. So if it sounds like I'm on my soapbox, it's only because I've seen this a million times and we're not the kind of lawyers that go into court. We like to be proactive, and I'm just trying to give you the information so that you can be proactive. Just talk to an attorney. They can steer you in the right direction. Last little thing, heads up, if you are classified as an employee, whether that be upfront or later on through statutory employment like we were talking about here, chances are you're going to be required to produce paperwork related to your citizenship. So if you're undocumented and you're trying to work with US-based companies, Usually independent contractor classification is going to be safer for everybody involved. There's obviously details around whether or not you can do that, but that would be an area where you probably want to speak to an immigration attorney.
And I will jump back in here on other important contract clauses, which there are many. So we'll touch on some specific ones here, but just generally speaking, a lot of the time people look at contracts and they sort of gloss over, and it's just this foreign language, and they really don't put much emphasis on what that legalese really is and how it can protect you and really protect both people that are entering into a contract. So there's a lot of different things that are considered boilerplate legalese, but again, they're super important. Things like indemnification. Indemnification is where one party causes liability for the other, and the party that causes the liability is the one that has to deal with it, handle it, and if there's a court case, go through that court case. And essentially, that indemnification allows that other person that didn't cause the liability to get out of that mess and not have to deal with it if everything goes according to plan. There's other things that are going to be really important, like a force majeure clause, or sometimes called acts of God. We saw that ad nauseum, another legalese term, I guess, during the pandemic, which really had a lot of different impacts for our clients, because with a force majeure clause, the whole point is if something happens that you have no control over and it has affected your ability to perform the contract, you should be able to pause or be excused from performing that contract. And so a lot of times that came up for weddings and events and event venues during the pandemic when we couldn't go out to those places. And there's, again, a plethora of these different provisions. I'm just hitting some of the high ones. Termination, super important. We've seen a number of situations where contracts are silent on termination, and then there's this ambiguity of how do you get out of the contract. And anytime there is uncertainty or ambiguity in a contract, it is almost always going to result in there being some type of disagreement or dispute. So the more clear your contract is, the better it is for everyone. And again, I'm going to stress that point that it's not just to protect yourself. Contracts that are well drafted are going to be mutually beneficial to the people that enter into them. And that is always our goal with our contracts, is to make sure that they benefit the parties mutually. Of course, for our clients, we're going to defer to their rights, but we're not going to have anything in our contracts that's unfair to another party. So some of the specifics that we have here: confidentiality, sometimes called non-disclosure, super important. If you're doing something that you don't want to be public for whatever reason, or the material that you're working on is something that you don't want to be public, if it's a situation like Olivia just touched on, where maybe there's immigration concerns or legal authorities for whatever reason, the more that you can keep this confidential, the less risk there is with those types of situations. And we'll be touching on some of that just given the state of the world. So we'll have a couple points here and there on how to protect your work and protect yourself if you are concerned about any type of, resident green card, undocumented situations. Now, this next one's super important, and it is something that I think most creatives often overlook because it's a little bit of a heady concept, and a lot of the time when you're doing your contract, you just want it done, and you don't think through some of the long-term consequences. And so with publishing or promotion, really, really important, again, as far as what's shared publicly, but also in addition to that, if let's say you hire someone to create something for you and the contract says that they can publish that stuff even though it was for you, and then you see it on, and we've seen things like this where it's on a billboard or a car wrap or a bus bench, and that wasn't your marketing avenue, and the artist that you worked with decided they were going to put that somewhere else. So a lot of different things with the intellectual property, obviously, because that is your work, but trying to illustrate here how the real world implications of these things can really impact your work, impact how it's perceived, and impact your risk level in life in general. So it's more important than just, I want to make sure I get paid for my work. And you'll see the note down here. I like to say this all the time. I think it's a really succinct way to help you conceptualize what contracts are for you, which is that they are your own personal legislation. So very important to know what's in there so that you know what is allowed and what is not. And so here we've been talking about contracts mostly, and I'm going to talk about how to register intellectual property in a second. But this is another way to protect yourself and to protect your work, which that is creating a business entity. So either an LLC or a corporation. Those are kind of the standard types of businesses you can have. If you're a professional licensee like lawyers or barbers or therapists, you have to have a professional corporation. Our law firm is a certified B corporation. A B corporation is a type of corporation that is essentially designed to have a double bottom line. It's both for the profits, but also for people and planet, so you can make an impact. And you could have a B Corp as an artist, you can have an LLC, you can have a standard corporation. You can't have the professional corporation, which is good because they're paying. You don't want that anyway. So with these, the reason that this helps to protect your work and yourself is that the concept with having a business entity, which I'm going to use that to refer to the LLC and corporation, is that that then is treated like a separate person by the law. So you as the owner of that company, that legal entity, you're separate and you're protected. If something happens that someone wants to sue, they have to sue the LLC or the corporation, that entity, and that is supposed to protect you personally from that liability. So that basically means that if you have, a home or a car, personal bank account, savings, 401k, that's all going to be separate from that business entity and protected because of that. So really important concept there to think about. There's certain things you have to do in order to maintain that protection with that business entity, but generally speaking, that's why those are so important. And you can even take it a step further where you can deal with how you want the intellectual property or creative work to be owned. There's some tricky things you can do where maybe you own it, and then if somebody sues the business entity, it's not up for grabs. Differently, you could have the business entity own it, and then that protects if somebody sued you personally. So there's different ways depending on your particular situation, which again, this is not advice for your particular situation, but there's different ways to structure these things that can really protect you and your work. And because of this whole concept of it being owned separately and it's considered a separate legal person from you, this can also help with situations where someone might be undocumented or be a naturalized resident that's concerned, because the entity itself can be the thing that's in the United States doing the work, and it doesn't have to be directly associated with you in a way that's going to cause you to be at risk. So with that too, one of the things that can be really helpful is if you have an ITIN, because you don't have a social security number, you can actually create a corporation or LLC with that ITIN. You don't need a social security number. So another great way to protect yourself and your work. Now, this is a little bit of a kind of extreme measure, but it is something that provides extreme protection. So there are really two types of trusts out there mainly for protecting your assets. There's what's called a revocable trust and an irrevocable trust. With a revocable trust, you can make changes to it, you can add stuff to it, you can take things out of it. But with an irrevocable trust, once you put things in it, and what I mean by things is it can be anything from cars to houses to bank accounts to family heirlooms to your creative work. It can be really any of those things. And once you put them into the irrevocable trust and you sort of formalize that trust, you can no longer change it. You can't touch it. You can't do anything with it. And the reason that that's so protective is that no one can also get to it and get the assets that are in it out of it. That irrevocable trust essentially acts as an almost impermeable barrier for any type of legal actions, creditors, someone trying to seize your work. And so the way that this can factor in is that your status doesn't affect your irrevocable trust in any way. And in fact, the irrevocable trust can live on beyond you. It can essentially have ways where it will distribute your assets if you pass. And so these things can be really, really effective and really can be set it and forget it. And then there's no way to get to those assets. And then the trust itself can be designed to pay money, the proceeds of any of the monetization of your work, to your family, to yourself, to another bank account, whatever you need to do. And so it's again, it's an extreme measure, but it is a really protective one. And again, you can see down there, it's permanent. So you definitely want to talk to somebody that knows how to put these together in order to make sure that that's working for you. And generally speaking, if what I'm saying here, it resonates with you about making sure that it goes to your family or that the proceeds go to people that you want it to, a revocable trust can do that. It just doesn't provide the barrier here that the irrevocable trust would. And so now we're going to talk a little bit about, we've been talking about IP this whole time, and we haven't really sort of drilled down into what makes up IP. We've said it's your creative work, and that's true because intellectual property is the broad umbrella for patents, copyright, trademark. And so within that, a trademark is what's called a source identifier. You can see the examples that I have here, the Nike swoosh, Just Do It. When you see those things, you know that whatever that product is with that on it came from Nike. It identifies the source being Nike. Similarly, there can be actual like product dress. And so trade dress is what they call it. Like the Coca-Cola bottle. I always say this one wrong and Liv always
I
asks me.
know what you're gonna say.
But it's the shoes. I'm not going to say it because I'm just going to describe them. It's the shoes with the red on the bottom of them. Like when you see that, you know the brand that I don't pronounce correctly. I can't even get words out when I think about the word. So I'm not going to say it. But those things are trade dress, and you recognize the source of them from that trademarkable aspect. So copyright, on the other hand, this is different in a lot of ways. So copyright is always going to be an original work of authorship fixed in a tangible medium. This is really important because if it's something that is has already been created and you just take that and do something with it, you're actually using someone else's copyright without their permission unless you make it into a transformative use. A good example of that is like, let's say there's art that's tangible, like paper, and you take that art and you create a digital collage out of it. That could be transformative. This is an oversimplification, so don't, again, act on what we're giving you here. But when you take it and you change the medium or you change the market that it would be in, that can sometimes be transformative. But if you just take something that someone already created and you post it or you use it or you monetize it, that's a derivative work because it's derivative of the original. And so things like this are going to be photographs, books, movies, scripts, sculptures, all of those types of things. When you think them up, they're not protectable because, again, they have to be fixed in a tangible medium. So when you come up with a concept for a movie or a book or something like that, be careful about who you pitch it to. Because if they go fix it in that tangible medium and write it before you do, you might have missed out. And so this is, again, a point just to make and draw us back to the contracts is confidentiality, contracts that lay out who owns what. Those are going to be tremendously important when you're pitching things early on because it can be easy to take them when they're not yet fixed in that tangible medium. Patents are also IP. I mentioned them a second ago, but those are going to be for things that are novel and utilitarian. So things that are new that create some new usage. So think about inventions and technology and things like that. We don't handle those, so that's why my definition of that is not as good. But they are definitely a type of intellectual property that we encounter, and we have good referrals for that type of work. So how do you protect these things? Outside of the contracts that we've talked about, which is something that you can control and you can do, and having a business entity like we talked about, another thing that you can do proactively to protect yourself. But there's also ways to register your trademarks and patents too, but your trademarks and your copyrights. And when you do these types of registrations, they are with our federal government. And then there's a database that you can point to and a certificate of ownership from that federal government office that you can use and you can point to say to other people that might be using yours without permission, hey, I own this, the federal government says so, here's my certificate, or here's the database you can look at. And the way we've been taught to think about your copyright or your trademark registration is that it's a sword and a shield. And what that means is that if somebody else out there starts using your trademark and you're losing business because they're confused and think that that's you, you can use your trademark registration as a sword to defeat that person that's infringing on your trademark. Similarly, if someone thinks that you're using their trademark, but you have it registered, the one you're using, that's your shield to fend off and defend against that action. Now, similarly with copyright, same concept. If you have copyright registration, you can stop somebody from infringing on it and you can protect yourself if someone accuses you. Now, to register these things, they can be pretty long processes. The trademark itself can range anywhere from $350, which is a one-class trademark application with USPTO, all the way up to thousands of dollars. I would say 2,000 is even low for some of the applications we've done. And it can take 12 months, even longer sometimes. And unfortunately, the USPTO has become pretty inconsistent and they've hired a lot of new examining attorneys. So we see some really weird office actions from that office nowadays. And so that is something that I'm just trying to illustrate. It's much more important to work with an attorney that has familiarity with the USPTO to help you navigate what is becoming an even more confusing and sort of not clear process. Now, copyright, a little bit more straightforward. That's a less expensive application, $35 to $65 typically, and it takes usually 5, maybe 6 months, and it's a different process. So trademark, you have to demonstrate that you're using that trademark in commerce publicly. So let's say you sell some type of clothing or apparel, you have to have that trademark on the tags or the clothing, and it has to be for sale for it to be in commerce. Copyright, not necessarily the same. Once you've created that copyright work, so the photos, the movie, the script, the sculpture, whatever it might be, once you've created it, remember that's fixed in a tangible medium, and now it is protectable under copyright law and you can register it. And you need to submit basically like photos for trademark showing that you're using it publicly. For copyright, you actually submit the work itself. So if you have a digital copy, you just submit it to them. You can send in physical things. Little harder with something like a sculpture, obviously, but you can put plans together and send that in for that. So generally speaking, what I would say, just to kind of wrap this for all of you guys before you go into the next session, is that the best ways to protect your creative work and yourself and who you're working with are going to be contracts, your business entity, and then also registrations of your intellectual property. I'll kind of tie this a little bit in a bow with something that we don't have written out here, but is something that we use as a framework for protecting yourself, called the 3 lines of defense. The first line of defense is your contract. That's the first touch point you have with who you're working with. It's the first place everyone's going to look if there's a disagreement. If something happens with that, if people don't want to pay attention to that contract, then you go to insurance. That's the second line of defense. Hopefully you have insurance that covers whatever the situation is. And if you do, hopefully it pays out, and that's that. That handles the situation. Insurance is notorious for not paying out. So the third line of defense is going to be that entity, that LLC or that corporation. That's always going to be sort of the backstop to protecting yourself and protecting your work. And then those IP registrations, trademark, copyright, those sort of factor into that puzzle, depending on maybe your LLC owns those registrations or something along those lines. So a lot of information, a lot of high level information, which is why we have some information here. You can reach out to us. We provide free consultations. Would love to talk to you about any questions that you have and help you make sure you're protecting your work and protecting yourself.
Awesome. Thank you all. So one of the things that stood out to me, this was great. This was so helpful, is it harkens back to my time when I worked for the Airport Authority, and I was working with in their temporary exhibits, managing the temporary exhibits program and the performing arts series that they have there. And my office happened to be right next door to the legal department. And that is where I learned the beauty of a good contract. Really understanding what you're signing, understanding, and if you don't, like, take the effort to understand what you're giving away, what you are signing. And when you said it, a good contract will protect both parties.
Mm-hmm.
And there will be no ambiguity. You have to go in thinking, what is the worst thing that could possibly happen? And how do I protect myself before it even happens? And we happen to have an attorney who's on our board of directors. We came across a moment where, I won't say too much detail, but the individuals that we were negotiating with, we had a great relationship with them. We can, to this day, we have a great relationship with them. And the contract said something like, if this happens, we don't have any obligation to inform you that it's a danger to your audience. And we were like, well, yeah, of course you do. But going through the legal process of getting that changed in the contract seemed like such a big task that we almost stepped away from it, and we're like, just sign it. They're going to tell us. Of course they're going to. Why would they tell us?
Important, yeah, like that, and it can ruin a relationship if the contract was just thrown together and not actually customized for the situation, because then you can imply into that was intentional or nefarious. So yeah, great point,
Right.
Suzanne.
It wasn't intentional. Yeah, I mean, maybe, I don't know, who knows what but we were negotiating with a very large corporation. So, getting something changed costs them thousands and thousands of dollars, et cetera. And so she said something that stood out to me that I'll never forget. I said, no, we have a great relationship with them. Of course they would tell us. And she's like, well, you have a good relationship with them until you don't.
Yeah.
Right. And you don't maybe have that relationship with their legal department who drafted the contract and doesn't have the information that you've discussed with your contact at that big company.
Well, and one thing that a lot of people, I think, don't even realize, there's usually a clause in contracts that says, if this company or this organization is bought out, there's a merger, this contract is still going to be in effect. So you might have a great relationship with whoever you signed it with, but over the term of your contract, that person might leave. That company might be purchased. You might end up working with a completely different person down the line that's a little bit less flexible with you. So ideally your contract is drafted in a way that you understand and that does have flexibility built in for the areas where you know you'll probably need flexibility.
Yeah.
Mhm. Yeah. Yeah, this is so helpful. Thank you. And, everyone who's watching today, really take the time, invest in and the folks at BetterHelp, I can't recommend them even more. I mean, they are so accessible. They make everything make sense for you. As he mentioned, they offer free consultation, which we've taken them up on. And, they are genuinely, as you mentioned, a B Corp. So they are really genuinely here to help the community. And I'm so glad that we got to introduce you to them to you today. Well, thank you both so much for being here. It's really just such an honor to have you in our community. Thank you for all of the good work that you do. We're really grateful.
Thank you for having us, and thank you for the work you do as well.
Thank you. Okay, everybody, stick around. Our next session is the future of creativity, AI, and the arts with the amazing Sharon Guy. Stay tuned.